has rarely, if ever, been greater. On the campaign trail, the American people witnessed Donald Trump glorify sexual misconduct, mock a disabled reporter, and make disparaging remarks about immigrants and minorities. We all witnessed chants at Trump rallies of "lock her up." At his confirmation hearing, Senator Sessions excused these as, and I quote him here, "humorously done." But in mass rallies that also featured people getting beaten and the press caged and vilified, this didn't seem very humorous to many Americans. I think Americans know that the good guys in the movie are not the ones in the mob. The good guy is the lawman who stands on the jailhouse porch and sends the mob home. That "lock her up" chant, to me, was un-American. And I believe across the country it made honest prosecutors' stomachs turn. Not surprisingly, many Americans are fearful of what the Trump administration will mean for them, for their families, and for their country. The problems with this president did not end with the campaign. President Trump and his family have brought more conflicts of interest to the White House than all other modern presidents and families combined. The proposed Trump domestic cabinet is an unprecedented swamp of conflicts of interest, failures of disclosure and divestment, and dark money secrets. We have not even been permitted in the course of our nomination, advice, and consent process to explore the full depth of that unprecedented swamp, because the dark money operations of nominees, of emails, are still covered up. The Trump White House traffics in alternate facts, operates vindictively, and is a haven for special interest influence. None of this is good. All of this suggests that there will be more or less constant occasion for investigation and even prosecution of this administration. Independence is at a premium. Nothing could have made this more clear than the first disagreement between the Trump White House and the Department of Justice, whose outcome was that the acting Attorney General, a woman of 30 years' experience in the department, a career prosecutor, former Assistant United States Attorney, former United States Attorney, and someone recognized for her leadership throughout the department, was summarily fired. This is also not a good sign. In recent history, Attorneys General Gonzalez, Meese, and Mitchell were politically close to their presidents, and the Gonzalez, Meese, and Mitchell tenures did not end well. Attorney General Mitchell worked for President Nixon. They met when their New York law firms merged in the early 1960s, and they became law partners. John Mitchell was the campaign manager for Nixon's 1968 presidential campaign. There were signs that things weren't quite right, because when Nixon nominated Mitchell to be his attorney general, he appealed directly to FBI Director Hoover not to conduct the usual background check. Mitchell ultimately resigned as attorney general in order to run President Nixon's re-election campaign. Ensued. Attorney General Mitchell turned out to be a central figure of the Watergate scandal. As the chairman of the re-election committee,
This is Senator Sheldon Whitehouse speaking on the nomination of Jeff Sessions.
While still Attorney General, that dirty tricks program ultimately included breaking into Democratic National Headquarters in prison. Attorney General Edwin Meese was also very close to President Reagan. Meese joined the 1980 Reagan presidential campaign.
This is Sheldon Whitehouse, senator from some state, and he is speaking on the nomination of Jeff Sessions.
Edwin Meese was given the job of leading the Reagan transition. And once in office, Reagan appointed Meese counselor to the president. According to press accounts at the time, Meese was known as someone who, quote, that was the political background between Meese and President Reagan. Again, it did not end well. Meese came under scrutiny for his role in the Iran-Contra scandal, had failed to take appropriate steps to prevent members of the administration from destroying critical evidence. An independent counsel named Lawrence Walsh finished a report in 1993 that stated that Meese's false statement when he said that Reagan had about 1985 Iran-Contra deal. The controversy that plagued Attorney General Meese, a company called WED Tech Corporation was seeking Department of Defense contracts in the early 1980s. The company hired Meese's. Well, the contract was awarded to WEDTech, and then one of Meese's top deputies went to work for WEDTech. The Federal criminal investigation that resulted led to the conviction of E. Robert Wallach, the former law school classmate and personal attorney of Meese, for whom he had set up the meetings with the government. Independent counsel James McKay investigated the WEDTech contract, including investigating allegations of misconduct by Meese. While Meese was never convicted, he resigned following the issuance, who are politically close to a president coming in harm's way and doing poorly in the department. One particular office that is vulnerable to this kind of undue proximity and failure of independence is a body in the Department of Justice called the Office of Legal Counsel. Jack Goldsmith, a former head of the Office of Legal Counsel, and a Republican, by the way, testified before the Senate Judiciary Committee that, and I'll quote him here, more than any other institution inside the executive branch, OLC is supposed to provide detached, apolitical legal advice, and it has an honorable tradition of providing such advice to a remarkable degree. But under the Bush administration, the OLC departed from that tradition. It came up in a number of ways. The first was during our investigation into President Bush's warrantless wiretapping program, when Office of Legal Counsel memos supporting the program came to light. I plowed through a fat stack of those classified opinions that were held in secret over at the White House and pressed to have some of the statements declassified. Here are some of the statements that were declassified, found in those OLC opinions. I quote, "An executive order cannot limit a president. There is no constitutional requirement for a president to issue a new executive order whenever he wishes to depart from the terms of a previous executive order." So this means that a president could issue an executive order, have it published in the Federal Register, put it forward as the policy of the administration, a direction to all the attorneys in the administration, and then secretly depart from it without ever changing what the public is told about the policy. A theory like this allows the Federal Register, where these executive orders are assembled, to become a screen of falsehood behind which illegal programs can operate in violation of the very executive order that purports to control the executive branch. That was just one. Another one, I'll quote, "The president, exercising his constitutional authority under Article 2, can determine whether an action is a lawful exercise of the president's authority under Article 2. If that sounds a little bit like pulling yourself up by your own bootstraps, well, it sounds that way to me too. And it runs contrary to a fairly basic constitutional principle announced in the famous case of Marbury versus Madison, which every law student knows, which says it is emphatically the province and duty of the judiciary to say what the law is. A third example, and this is another quote from an OLC opinion, "The Department of Justice is bound by the president's legal opinions. Well, if that is true, what is the point of a president sending matters over to the Department of Justice for legal review? If the president did it and it's therefore automatically legal, there would be no function to the Department of Justice accomplishing that legal review. So in this area of warrantless wiretapping, the Office of Legal Counsel within the Department of Justice came up with what seemed to be quite remarkable theories that are really hard to justify in the broad light of day. That's why independence matters so much. Obviously, the White House wanted those opinions to say what they said, but in the clear light of day, they don't hold up. Let's move on from the warrantless wiretapping opinions of the Bush Department of Justice to the OLC opinions that the Bush administration used to authorize waterboarding of detainees. Again, review the OLC opinions. And when I read them, I will say I was quite surprised. I was surprised not just by what they said, but by what they didn't say. One thing that was entirely omitted was the history of waterboarding. Waterboarding was used by the Spanish Inquisition, by the Khmer Rouge in Cambodia, by the French suppressing revolts in Algeria, by the Japanese